range of business and individual law services. Practice includes corporate, dispute resolution, commercial property, all the way through to employment, family, all the way through to personal injury and clinical negligence. So it's a full service law firm based here in Kent. So without further ado, these two people we have today are Nick Hobden. He is head of the employment team. He is ranked in Chambers and Partners directories from 2011-19 as a leader in his field. Obviously fairly big field, which is good. And he's in the Legal 500's latest edition. So he's top drawer, one of the elite leading lawyers, according to Legal 500. So that's impressive. I'm doffing my cap. He's experienced in handling all aspects of employment law, but particularly advice on clients on complex, highly confidential, sensitive and difficult business restructuring exercises. And I think that sort of advice, that sort of know-how is going to be needed now more than ever before. It's all about 2P, issues relating to various conditions of employment, paying conditions, and all these sort of areas. So delighted that he's here with us today. He's joined by Michelle Rule, who's a corporate and commercial team associate. She specialises in helping clients with a wide range of commercial aspects, such as terms of business, non-disclosure agreements, contracts and commercial agreements, GDPR, we all love a bit of GDPR, and data protection issues, intellectual property licenses, protection registration, the list is endless. And she brings with her 15 years of experience in the technology, e-commerce and online publishing and digital vending, renewable energy sectors. So again, another expert. So without further ado, I'm going to ask Nick to do his screen. But actually, before I do that, Nick, just a bit of housekeeping. Can I look at the housekeeping slides? Are they there? Right, okay. So please keep your camera on if possible. Keep your microphones on mute. It avoids the bird chorus or the dogs in the background, the diggers going past, all those sort of things. And what we'll do is, during the presentations, please feel free to use the chat functions to ask questions. If you can send them privately to myself and also to Molly Hall, who's our co-host today from the Chamber. I will then look at those questions as we go through the presentations, and then at the end of the presentations, I'll do a bit of a Q&A session with Nick and Michelle, and then we'll have a roundup at the end of the session. I hope that all makes sense. I hope that was relatively coherent. I am powered by coffee today. So without further ado, can I pass you over, please, to Nick Hobden. Over to you, Nick.
Thank you very much, Andrew. So with the wonders of modern technology, I'm going to share my slides with you now. Here we go. Can you see that, everybody? Yeah, just thumbs up will do. Thank you very much, Molly. Yeah, excellent, great. So, ladies and gentlemen, there has been a lot of noise about easing the lockdown and returning to work. The government have issued no less than 8 separate guides to returning to work by sector. I'll take you through to those in a minute, but these are the subjects I'm going to be covering this morning. The whole gamut of the risk around returning to work, from risk assessment to PPE, where I have some certain views at the end. So if I just escape from that and go into another slide, which, can you see that? This is the government website. Thank you. Molly, can you see that? No? Okay.
No, it's not coming through, Nick.
It's not coming through. So, okay, I think I have to share another slide. But anyway, I'll dispense with that and come back to my slides. So essentially, if you visit the government website, ladies and gentlemen, the gov.uk website, and you go to the work section and you scroll down to the area where it says health and safety, you click on that and you will find the announcement from the Department for Business, Energy and Industrial Strategy, dated the 11th of May, issuing 8 guides. Now these 8 guides cover construction and other outdoor work, So guidance for people who work in or run outdoor working environments. So this includes horticulture and agriculture. There's one on the factories, plants and warehouses, one on labs and research facilities, offices and contact centres, one on other people's homes, so guidance for people working in, visiting or delivering to other people's homes, restaurants offering takeaway or delivery only. So you'll be aware, ladies and gentlemen, that we're not able to go out to restaurants and pubs anymore, but we can pick up a takeaway. So there's guidance on that. Shops and branches, and finally the 8th bit of guidance is on people who work just in vehicles, so couriers, mobile workers, lorry drivers, on-site transit, etc. So what are these guides aimed to do? Well, they are aimed to help employers and workers provide a safe working environment and safe system of work as we go through the easing of the lockdown. And as well as complying with existing obligations, and way back in 1974, when I was about 11 years old, the Health and Safety at Work Act came out, and that is still in force and still prescribes that employers have the obligation to provide a safe system of work and a safe working environment. It's particularly relevant now because if employers don't provide that, then they could be A, prosecuted by the Health and Safety Executive, and B, they can be on the receiving end of claims which they have to have their insurers deal with. The guidance also refers to people with protected characteristics under the Equality Act 2010, such as those with disabilities. And indeed, the guidance refers to those with disabilities who may be at high risk of catching COVID-19 and serious consequences thereafter. Now, the cornerstone of the guidances are about enabling workers in those environments to observe social distancing as much as possible. And that means that employers need to carry out a risk assessment, a COVID-19 risk assessment. And they have to do that just as they would do for other health and safety related hazards, but this is a specific COVID-19 one. So all your health and safety risk assessments that you've done previously, and you've got policies, forget about those, because you have to do a specific COVID-19 risk assessment. And that has to be done in consultation with your staff through the unions or worker health and safety representatives. So a workplace health and safety representative must be selected by a recognized trade union if you have one, but if you don't have a recognized trade union in place, then the health and safety worker representative has to be chosen by your workforce. You can't simply randomly pick someone and say, you'll do, come and have a discussion about this risk assessment. They have to be chosen by the workers, and they must be involved in the discussions. So listen to what they have to say and don't ignore them, and allow them an opportunity to consult with their, those people that they represent, because any attempts to stop them doing so will mean problems for you in agreeing the risk assessment, and also potentially challenges in terms of legal claims. Now, managing risks. The guidance, interestingly, starts with a passage on hand washing frequency and surface cleansing, and then starts to go into details regarding whether people can work from home. And the general presumption is that people should work from home and continue to do so for the foreseeable future, and that you should facilitate that as much as possible. Only when home working is not possible should every reasonable effort be made to comply with social distancing if you invite them back into the workplace, keeping people 2 meters apart wherever possible. And if social distancing cannot be followed, then this raises the question of whether you should be actually opening your site, your office, at all, or a particular part of it, placing workers at risk of not being able to observe the 2-meter rule. So you will need to consider that, and you will need to consider the mitigating actions. The mitigating actions are as follows. 1, keeping the activity time involved as short as possible, using screens or barriers to separate people from each other, using back-to-back working rather than face-to-face working in terms of desk layout. Side-to-side working is also permissible, reducing the number of people each person has contact with by using fixed teams or a partnering system so that each person only works with a few other people. And guidance says that no one is obliged to work in an unsafe work environment, particularly those who are especially vulnerable to COVID-19. Your next step after you've agreed the risk assessment is to share the results of that risk assessment with your workforce and publish the results on your website. That's what the guidance says. And the guidance also suggests that you provide a template notice that should be clearly displayed in your workplace. Here is one which is in the guidance, and that sets out 5 steps to safer working together. And that must say these 5 things. 1, that you have carried out a risk assessment and you shared the results. 2, you have cleaned the place well, and you have hygiene and hand washing procedures in place. 3, that all reasonable steps have been taken to help people work from home. And if not, that all reasonable steps have been taken to maintain the 2-meter rule. And where finally, on the 5th one, where people cannot be 2 meters apart, that you've done everything possible, my emphasis, everything possible, to manage the transmission risk. And that, folks, is going to be the area where I think that's going to be the most challenge for employers, where they do bring people back in and have to demonstrate they've done everything possible to manage the transmission risk. So, the comings and goings. Who is to go into work? Well, when deciding who's to go into work, employers must consider who is essential to be on site and allow others to continue working from home. Those remaining on site are likely to be those that are critical for your business in terms of business continuity, safe facility management, or regulatory requirements which can't be performed remotely. And then you must consider what is the minimum number of people that you can operate in the workplace doing these roles and keep them safe. The guidance considered that in all areas, including even construction, that support and office workers can continue to work from home, and that on a construction site, you can bring people back in as long as you observe the 2-meter rule and using small fixed teams. The message is keep your workers safe and they still can connect with their colleagues in a distancing way. And a word on vulnerable. One of the objectives of the guidance is to protect the clinically vulnerable and also the extremely clinically vulnerable. And there is a difference. And you have to look at separate guidance to find the distance. So extremely vulnerable are those who have to shield and are required to shield themselves from any contact with other people whatsoever. And those are people with who've undergone an organ transplant, who are undergoing treatment for lung cancer or other cancers, chemo or radiotherapy, who have severe respiratory problems, with heart disease, and they have to be shielded. So it's difficult to see how they can be brought back into work at all. In fact, it's impossible to see how they can be brought back into work. Vulnerable individuals, on the other hand, are those who are 70 years or over, or those under 70 who have a health condition such as a respiratory condition, heart disease, kidney disease, liver disease, type 2 or type 1 diabetes, or pregnant women. And also you have to make sure that in those circumstances that the prospect of them coming back to work is extremely remote, and they will need to stay at home. And similarly, if you know of someone who's living with someone who has got COVID-19 or COVID-19 related symptoms, then they clearly must self-isolate, and there's absolutely no way that you can bring them into work. Now, arrivals and departures, there's guidance for those coming into and leaving work to maintain social distancing. And this bit of the guidance kicks off with hand washing upon arrival. That's important. Hand washing facilities, sanitizers, staggering arrival and departure times to reduce crowding in and out of the workplace, providing additional facilities for those who, for example, want to ride a bicycle to work, providing bike racks, or additional parking spaces for those who are not going to rely on public transport and wish to go to work in their cars or on motorbikes. So the message here is if they can reduce use of transport, public transport, then this is to be welcomed. This does mean, of course, having more entry and exit points in the workplace and using markings and one-way flow entry and exit points to provide safe passage for people coming in and leaving the building so they remain 2 meters apart. You'll want to consider their storage facilities where they're going to hang their coats up and bags so that they don't cross-contaminate. Even the entry system, if you've got a key fob or keypad system in place where they swipe or hold a key fob or card against a reader, then the guidance suggests you might want to deactivate that and simply allow someone to let them in, keeping their distance of 2 meters. Now, managing social distancing in the workplace means, in the context of offices and other clerical work, no hot desking. And if hot desking is absolutely necessary, then workstations should be shared by the smallest number of people and deep cleansed between occupancy shifts. You want to reduce job and equipment rotation as much as possible. And again, the guidance repeats the one-way flow system through the building. You also want to consider reducing non-essential trips within the building, for example, to the copier or to the stationery cupboard, for example, or to the kitchen or the canteen facilities. Limit the numbers of people. And on site, you also want to consider designating zones where few people can work around a particular task on site, and that they don't mix with other people. Now, we've all experienced going into supermarkets and other food stalls to get essential items, and we've all seen the blue or yellow or cross-hatched marking on the tape, and it is suggested by the guidance that you implement that form of designation as well to ensure that you maintain the 2 meter social distancing rule. So if you have someone sat at a desk, as I am here, then 2 meters apart around from me, you want to draw a circle around my desk to ensure that I don't come into contact with anybody within 2 meters. Meetings, that's going to be a challenge, isn't it? Because the instinct when we go back to work is to want to hold meetings. But the message is don't. You can Skype or Zoom or House Party or WhatsApp or Microsoft Teams from your desk, even to a person in the same building, without meeting them. But if you absolutely have to meet them, then make sure that you take your own pen into the meeting and they take theirs, and you properly sanitize your hands when you go into the meeting, and clean all surfaces before and after the meeting to protect from contamination. I think one of the biggest challenges, and certainly ones facing us where we occupy a building in Dartford with other occupants, is to maintain consistency in common areas such receptions and staircases. And you'll need to work with landlords and other tenants in multi-occupied buildings to ensure consistency here. You'll need to look at staggering break times to reduce pressure on break rooms or places to eat, using safe outside areas for breaks, provided it sunshines, creating additional space, using protective screening for staff in reception areas, encouraging storage of personal items in personal storage spaces, and regulating the use of locker rooms and changing areas to reduce concurrent usage. If you provide a catering facility, then you will probably need to provide pre-packaged meals to avoid staff being contaminated in going to canteen areas where you're serving food, because that essentially is akin to a cafe or a restaurant, and all those places are still in lockdown. And you also need to reconfigure seating and tables to maintain spacing so as to reduce face-to-face interactions. Now, the guidance also talks about cleaning, and this is to do with cleaning in before we set foot back in the office. You need to give the place a good deep clean and restrict the use of high-touch equipment with plenty of hand-washing sanitation facilities. So for example, if you use photocopiers or printers, then consider designating one staff member only to be responsible for the printing and the scanning. Don't be tempted to get out of your desk and visit the printer, because unwittingly that could create a problem with contamination. And finally, on PPE, the guidance says that unless employers are in a situation where the risk of COVID-19 transmission is very high, then the risk assessment should reflect the fact that the role of PPE, personal protective equipment, and providing additional protection is extremely limited. However, if your risk assessment does show that PPE is required, then this must be provided free of charge to those who need it, and such PPE must fit properly. Now, I actually have to say that in my view, the guidance has not gone far enough here, because we've had a lot of news press coverage on the need to wear face masks whilst travelling on public transport and in other high risk areas. And there's even a suggestion from one former chief medical officer on the news programs this morning that people should be fined for not wearing face masks. So I have to say that I am leaning towards the recommendation that you may need to prescribe the wearing of face masks in the office to protect people. And if you do that, then in the words of one eminent professor scientist, that if you are going to allow people to have their own face masks and make their own, then you should insist that the cloth that they use is not loose weave, but close weave, because that is the safest form of homemade mask protection. Particularly denim is close weave. So if anybody wants to start tearing up their jeans and making them into face masks, then that would actually be a safe route forward. Because actually, there are two forms of contamination here. There is the aerosol effect. As I'm speaking, I'm emitting an aerosol range of spray and droplets. And if I wear a close weave mask, then that will restrict the permutation of that aerosol effect. It will certainly eliminate the droplet effect, and that's why we have the 2 meter rule to protect people from the droplet effect of contamination. So that's all I have to say on coming back to work. Best of luck, and I'll take some questions.
Thanks, Nick. I bet you never thought you'd be an expert on sort of making face masks out of denim and sort of the differences between loose and close weave cloths in a health and safety environment. We've had a number of questions, but before I kick off on them, just going on to the specific COVID risk assessment you mentioned and choosing a member of staff to do it. Do they have to have any specific training to be able to take that forward? Because I'm just thinking from my perspective, we're a team of 8. None of us, with the exception of the office manager, have had probably health and safety training. You know, where do you start? How do you identify the best person?
The guidance doesn't actually mention that the health and safety representatives should be trained in health and safety, but conversely, there is legislation that says that if they are going to do some training, they should be allowed reasonable time off to train and be supported for that. So my view is that yes, you should train them. You can access a number of online training courses on the health and safety, but also they need to be familiar with the guidance and think logically and laterally about the effect of the guidance and on this area of working environment.
And is there a minimum size in terms of company size for actually doing a COVID risk assessment, or do you have to do one regardless if you're a 1, 2, 3 man band? What's the...
Well, the guidance says for small businesses that you don't have to write your risk assessment down. I actually don't agree with that, because I think if you go to the trouble of conducting a risk assessment, you ought to have something to show for it,
exactly.
Particularly if you're challenged. The answer is yes, all businesses should do it. Even if you're a family business in a small office, you should do it.
Okay. And one of the questions come through was you mentioned a specific poster. I think it's to do with the template for the template notice. Is that, where can we find that? That's online at a government website, is it? Or?
Yeah, it's online in the government website. What I'll do is I will show you that guidance now, if I can. Basically, Molly, you'll have to help me in terms of sharing screen. How do I share a different screen?
I believe if you click share screen, is there one that says desktop instead of PowerPoint?
Oh yeah, here we go. Ta-da! Here we are, there we go. So this is the government website, ladies and gentlemen, and it has the 8 guides. And if you click on each guide, so if we go to offices and contact centres, then we go to thinking about the risk, sharing your risk assessment. It's there anyway. It is a template within that guidance.
Thanks, Nick. Question raised about communal staircases in shared buildings. Who takes responsibility for this? The question is, we have a cleaner who comes once a week to do communal areas. Presumably that is not enough. What is the acceptable frequency of cleaning these areas? Any thoughts?
Yes, daily.
Daily, okay.
Yeah, and what we've done with our fellow occupiers in our building in Dartford is we worked with them to ensure a common approach.
Okay, and what about in terms of employees returning to work? An employee who lives with someone who is vulnerable or extremely vulnerable. Because obviously you talked about employees who are vulnerable, extremely vulnerable. What about if someone actually is a carer for them, but caring for them from home? Any specific rules on that? You should consider with them, because if they are looking after someone who's extremely vulnerable or vulnerable, then you should really allow them to stay at home working. We have an example within our firm that I know of,
someone who has a child who is extremely vulnerable. And we've said really, as far as their return to work is concerned, that they should remain working at home in the interests of protecting that child.
Okay. Nick, could you provide guidance on staff who state they are too scared to return to work? Are they then breaking their contract of employment?
If they're too scared to return to work, then you've got two factors here. One is that it could be considered insubordination if you've made a reasonable request for them to come to work and they ignore that, and it could be a disciplinary matter. However, there is a piece of the Employment Rights Act that would apply in these situations, where if someone who brings to your attention as employer a harmful or potential harmful health and safety risk, and you fail to do anything about that, then they could legitimately absent themselves from returning to work. Similarly, someone who has a reasonable belief that they are at risk of a serious and imminent danger, and that for those reasons they either left their post or refused to return back to their post, if you disciplined them or dismissed them, that would be regarded as a detriment or an unlawful, unfair dismissal. And I should tell you that there have been a number of cases in the health sector where some healthcare workers have taken a stand, particularly where they've been vulnerable, and said that they've apprehended a serious and imminent danger to their health and safety, and they've objected to going to work. They've pushed back, they've stayed at home, and then you roll the story along and some of their colleagues who were at work contracted the virus and died. So their decision was completely vindicated. Yeah.
And finally, before we move on, because I'm just conscious of time, but we can, with the Chamber's Zoom account, we can go over the hour. So I hope everyone's okay with just taking one more question. The government guidance for when businesses should open as offices can reopen is rather vague. We all know we should work from home for the foreseeable. However, once some hospitality and businesses such as salons open in line with step 3 of the government's measures, should it be that offices could and should open with this guidance? I'd be interested to hear thoughts on a timeline for reopening. For example, if an office can operate safely and implement all advice, plus the employees are happy, shouldn't they reopen now, or shouldn't they reopen?
Yes, they should. And indeed, we're already seeing some people going back to work. The motorways are busier, the roads are busier. There are some organisations who are saying, well, let's wait until the kids start to go back on the 1st of June, and then we'll review the position at that stage. I can't tell you when Thomson Snell Passmore office will be open for some of us, not all of us. But I estimate that will be sometime after the 1st of June. It's a matter for the individual employer to consider. And as I say, the risk assessment is key to this. If, having done the risk assessment, you think that it's actually too early to bring any of your staff back, well, then you should continue to keep them at home or indeed furlough them. If some people can come back, then that's fine. But if not all of them can come back, and you have to wait until we have a situation where the R word, that's the rate of infection, stays below 1 for quite a number of weeks, then that's obviously going to be helpful.
Okay, brilliant. Thank you, Nick. Right, I think, Michelle, it's now your turn to provide us with a presentation. So Molly and Michelle, if you can share your screen, that'd be great. Thanks, Nick.
Right. Hi, hello everyone. Thanks to Andrew for my CV. So I'm a commercial solicitor, so I'm focusing more on the interfaces that you have with your contracting partners. And when this all first started, the great deal of inquiries that I got were about things that go by the name of force majeure and frustration, which is essentially where performance of your contracts is impossible given the government guidelines in relation to COVID-19. Now, the distinction here is that that's opposed to it being commercially undesirable, i.e. it wasn't commercially viable or desirable for you to fulfill a contract. It had to be impossible. As the government starts to lift restrictions, we're moving into contractual performance in a slightly different context. And actually, I can imagine that for some organisations, it's actually going to be worse for them, because to a certain extent, force majeure and frustration can provide a kind of protective bubble. The music has completely stopped. Whereas when the government lifts the restrictions, you are able to perform some of your contracts, but it's going to get a lot more difficult. And if you're in a contractual situation where you have service level agreements or penalties or liquidated damages potentially if you underperform, this could be commercially more damaging than not doing anything at all. So we're into the sort of murky realms of contracts, the boilerplate provisions, and maybe some insurance provisions that you have with third parties. But everyone is affected. All parties to contracts are going to be in a position where they're going to have some problems. It won't be business as usual. There'll be a lack of public transport, social distancing, shielding, and illness will lead to labour shortages. As Nick's pointed out, you're going to have various people who simply can't or won't come back to work. Because of social distancing requirements, your handoffs between you and your counterparties may be different. I was talking with a client the other day who is unloading lorries, and ordinarily they would have a small army of people would unload a lorry very quickly, whereas now, because it's in a confined space, only one person at a time can unload a lorry, and obviously it takes significantly longer to do so. So that sort of thing happens. There'll be travel restrictions that will impact international trade, and the supply chain, as we can all imagine, is in complete disarray, bits and pieces all over the place, various businesses in different states of restarting work. So it's not going to be easy. To add to all this, on the 7th of May, the government issued some guidance on contractual matters. And this it's only 5 pages long, it's not extremely long. And it boils down to a request rather than an obligation to play fair amongst contractual counterparties and to give each other a bit of slack. And there's numerous references to the phrase responsible and fair behaviour. In particular, the government have said that the reason that they want us to pursue responsible and fair behaviour is to maintain the supply chain to deal with the emergency situation that we're in particular in the healthcare sector, to keep businesses in the emergency supply chain financially viable, mothballing our contractual relationships and our business infrastructure where contracts can't be fulfilled, and being ready to kickstart the economy when feasible to do so. And I think the subtext of all of that essentially is we're trying to avoid a calamitous recession after COVID-19 impact has passed. So there's 3 main areas to consider. I'll start with suppliers, but the other 2 areas are obviously your customers and then your ancillary business services. So in relation to suppliers, I think the first step is to perform a form of sort of critical analysis of your supply chain. Who is really critical to getting your business up and running, and work with them first. Particularly important is to look at payment terms with your counterparty. If you've got cash and they haven't, you may want to consider setting up a prepayment arrangement in order to finance them providing you with supply. Alternatively, if you're in arrears, talk to your suppliers about time to pay arrangement or enhanced credit terms. You also need to understand where in the supply chain the stock is and the quantity of it and how it can be delivered to you. In terms of your options for dealing with suppliers, the ideal scenario is to seek to vary contracts by agreement. This is the safest route. You need to check a couple of things with in your contracts. First one is whether you have a no oral modification clause. If you do, that means that you must get the agreement to variation in writing. Recently, there's been a case which upheld that no oral modification clauses are binding. So if you just have a chat with your supplier on the telephone, that's not going to be good enough. You're going to need to get something in writing. You also need to check what the notice requirements might be in relation to your contract if you're going to vary it. When you're pulling your variation agreement together, just do a bit of what-if analysis before you agree with your supplier what the variation is going to be. It might be a one-time chance to deal with all the future possibles that might happen. So think about the what-ifs of retightening restrictions, if stock becomes unavailable, what if a key supplier falls out of the supply chain for whatever reason? What if you are suddenly closed on health grounds because, for example, there has been a case of COVID-19 in your business? So you need to sort of pull all that together. If you can't get your suppliers to agree to a variation, you could look to your contracts and see if you have a material adverse change clause. Material adverse change clauses tend to be in larger value contracts and essentially are there to deal with extreme changes in circumstances, which we may be in, but they are interpreted extremely narrowly. To invoke a material adverse change clause, it needs to be a substantial and permanent change. So substantial and permanent change. If you invoke a material adverse change clause and your counterparty doesn't agree with you, you could be accused essentially of a repudiatory breach of the contract. So be very careful and that you believe a substantial permanent change has occurred. Under some construction contracts, there's a sort of change in law clause, which I know some of my construction colleagues and their clients have been using to help them deal with the current circumstances. So that's another area to look for. And as a last resort, potentially with suppliers that you're unable to vary the contract with, you could look to see whether there's a termination on notice clause. So essentially, this is a sort of cutting your losses scenario. Again, check the notice requirements and make sure that you comply with this timing and whether it needs to be in writing and so on and so forth. Something to consider when dealing with suppliers in terms of the what-if scenarios is, could you look to find new suppliers who may be able to help supply into your business? Or alternatively, you can work with new or older suppliers in option-based contracts. So these will have a cost attached to them. You will have to pay for the right to invoke a contract at some point in the future should you need to. But that's another way of potentially insuring against shortages of stock. Technological solutions to dealing with your supply chain, these will be industry specific, but you can look to increasing your IT provision or doing things in a different way, or mechanising potentially things that have previously been done by hand. Lastly, I just wanted to mention the insolvency provision changes. Back in late March, the Business Secretary announced that the insolvency regime would change slightly in the current circumstances. And I'll talk a little bit about how that impacts directors in a little while. But part of the proposals in the insolvency changes is, going forward, suppliers will be prohibited from terminating supply agreements in exchange for preferred creditor status. So this hasn't come into force yet. We haven't been told when the legislation is going to be laid out, but it relates to a Law Commission review from 2018. But essentially it means that if you are an essential supplier in a long-term supply contract, or have a supplier in a long-term supply contract, they will be obliged, even if you're in financial difficulties, to continue to supply you in order to aid the bounce back or recovery of your business. If you are the supplier, this may not be how you want to move forward, and you will be able to show that working with a potentially insolvent customer will cause you hardship, financial hardship, but you will have to go to court to get a court order to deal with that. Thinking about how to manage this, it may mean that going forward, supply contracts will be more in the notion, more drafted towards short-term rolling contracts rather than long-term arrangements, so that they can be effectively ended at relatively short notice. But that's something that's sort of on the blocks, but we don't have any further details yet. In terms of dealing with your customers, again, you need to sit and think about who they are and what state they're in. What does your demand look like? Do you even have customers at the moment? Are your customers up and running? Look to match your supply to your demand. What value have you already got sitting in stock? Obviously, it'd be great to monetize anything sitting in a warehouse without having to invest too much more in production. And then also you need to think about the financial status of your customers. You don't want to become exposed to businesses or customers that are in financial difficulties themselves. So your options are, I would suggest taking an immediate review of your terms and conditions and to introduce a bit more wiggle room into your delivery terms in your terms and conditions. So if you would ordinarily allow yourself 3 days, maybe think about 7 days. If you would ordinarily allow yourself 7 days, maybe increase these to 21 days. If they're standard terms and conditions, you can amend them as and when you see fit. If you've got bespoke agreements with customers, again, look to a variation arrangement. Look to potentially be talking to customers about varying delivery terms, withdrawing credit, or maybe requesting prepayments or pay when paid clauses, and possibly adding in retention of title clauses. So if you're in a goods supply industry and you are passing goods on to maybe a retailer or a wholesaler, you need to ensure that you have retained retention of title if that retailer or wholesaler doesn't pay you. If you put a retention of title clause in, you need to ensure that it makes that your customer understands that they must keep your stock separate and it must be identified as belonging to you. Okay. One thing to bear in mind, if you already have credit insurance or factoring arrangements in place, maybe with your bank, before you rearrange your payment terms with your customers, just make sure that you are not breaching your arrangements with those credit insurance or factoring partners. The next alternative is to potentially terminate for cause. So if you're genuinely concerned that your customer is financially unstable and is headed towards an insolvency, or you've had the gossip is circulating around the industry, some long-term contracts will have a clause in them that says, in the party's reasonable opinion, the customer is likely to enter some form of insolvency event. You will be able to terminate for cause on that basis. And last but not least, we're back to termination on notice. This again may involve some kind of financial penalty, but it might be worth cutting your losses with the customer if the risk is too great. Lastly, obviously, New World Order potentially has produced a new set of demands for different products and services. So it might be that you need to rethink exactly how you deliver to your customers and what they might want. I must admit, I was completely shocked when I found out Primark didn't have an online presence and is now sitting on 160 odd stores worth of clothes, unable to do anything with any of them. So that's customers. Support services. So these are your professional services around you. Just some very quick reminders on finance. I'm not going to go into the details of the various financial support packages that are available, but my key advice is go and talk to your funders as soon as you possibly can. Look to potentially restructure your debt or your payment provisions if it's going to take you a while to get to a cash flow position that you were before the COVID-19. Government loan options such as CBILS and the generous deferred VAT arrangements and prepay and pay arrangements that are being offered by HMRC should be grabbed with both hands. Your landlord, he's just another supplier at the end of the day, or she. You can talk to them about variation agreements as well, such as rent holidays or asking for forbearance or varying how you make your rent payments. Again, your lease is your contract in this case, and you will need to check the terms of the lease and how it deals with agreeing variations. If you do get waivers from your landlord, make sure these are in writing and comply with any variation or notice requirements in the lease. Licenses are a sort of slightly trivial but can be a real pain in the side, particularly where licenses have got named individuals. So just double check that the named individuals on your licenses are able to perform the roles for which they are licensed. If, for example, they happen to be, unfortunately, a vulnerable or an extremely vulnerable person, they probably won't be coming back to work and you may need to get the license issued in a different name. Do your hours or nature of trading, have they changed and require that your license needs to be amended? And just remember to get renewals done in good time, because as well as all businesses, the borough councils are also going to be short-staffed. Health and safety, just put it in here to remind everyone, obviously Nick's been through the details of that. And then to talk about directors' duties, going back to the insolvency provisions, we've had a moratorium in place on the wrongful trading provisions since the 1st of March. This means where you are knowingly trading in a financially precarious position. So you would not have personal liability as a director for doing that in the current circumstances. However, you are still responsible as a director to understand the financial health of your business, and you could still act fraudulently if you present your business to be in a better state than it actually is. Okay, so that you must still keep directors' duties in mind. Right, going back to the government guidance, the detail of what the government have outlined as reasonable and fair is quite long-winded. I've given you the link at the bottom of this slide to the actual document. As I said, it's not very long, and you would look to paragraph 15 to see what they would require us to be reasonable and fair. I'll just give you a quick summary, excuse me for reading slightly. Requesting and giving relief for impaired performance, requesting and allowing extensions of time, making and responding to full frustration changing law claims, requesting and making payments, making and responding to claims for damages, returning deposits or part payments, exercising remedies, claiming breach of contract and enforcing events of default, making and responding to requests for information and data, giving notices, making and responding to requests for contract changes and variations, making and responding to requests for consent, including funder consent, commencing and continuing formal dispute resolution procedures, requesting and responding to requests for mediation, and enforcing judgments. So it's quite a long list of things that they want us to be reasonable and fair about. But the important thing about this guidance, and I've been reading around this subject over the last couple of days because I was quite interested about it, is it has no legislative force. So you can imagine the legal community have gotten quite exercised about this, because what does it really mean? And in particular, English contract law is famed for the right of freedom to contract. And if you've put something in your contract, you should have a right to enforce it. What the government seems to be implying is that they're maybe asking us not to enforce our contracts necessarily, or to imply potentially that in the future, if we're not playing fair and being reasonable and fair in our approach to contractual relationships, that they may legislate further. Interestingly, there's been a sort of think tank approach to how contracts are going to be managed out of the back of COVID-19. and some previous presidents of the Supreme Court were involved in this process, and they've said that it seems harsh, essentially, where an outcome in a contractual situation would leave one party a winner and the other a loser, when everyone's trying to pull through and act in the best interests of the nation in relation to this. The exact wording that they use is, there's a case for adopting a more creative, graded, but nevertheless rigorous approach without prejudicing the underlying need for legal certainty. So what that means is anybody's guess. So whilst I'm telling you that the government's guidance has no legislative force, you need to think about public perception. If you get caught publicly being very hard-nosed and aggressive as a business, whether, even if it's not the courts that are adjudicating over your contracts, if there's some kind of regulatory investigation, for example, the Competition and Markets Authority are already indicating that they are going to take a very dim view of businesses treating consumers harshly. Question whether this guidance would have any judicial sway in a formal dispute. And then if you're in a business that have to deal with the government a lot and lobbying, again, if you've had a reputation for being particularly hard-nosed and difficult during these circumstances and acting in contravention of the government's polite request to be reasonable and fair, this may not go down well in the long term. And I think that's about it for what I've outlined. One thing that did occur to me that it might be worth just very briefly covering, which I haven't covered in my slides, is the issue of data protection in relation to health information. There is, essentially, you can request and process personal health information for individuals and staff members in relation to COVID-19 under special legal bases relating to health and safety and the general public health. So if anybody was concerned they may not be able to manage the data in relation to their employees about their health or maybe their family's health, then that's not the case. There are definitely legal bases available for you. And that's about it for me. So questions?
Thanks very much, Michelle. That's brilliant. The couple of, am I getting feedback?
I'm not, but.
Oh. Do you want to stop sharing? If you stop sharing the screen, Michelle, that'd be great.
Okay.
Thank you.
Oops. Yep.
Right.
Okay.
Thank you for that. You touched on the whole issue there of responsible and fair. You know, what's fair to one person may not be fair to another person. And I think that's quite challenging. But I think the court of public perception will kick in where businesses are doing the wrong thing where the public is concerned with regards to contract. We've already seen it with Sports Direct and Wetherspoons and everyone else. So that would be interesting to see what happens there. In terms of questions going forward, right, let's have a quick look through. Okay, this may be one actually for Nick. If an employee gets COVID from an unknown source, but they were in the office prior to symptoms, do we need to close the office and the office self-isolate? Also, if a visitor informs you they have contracted it and recently been to your office, what do you do? As a challenge.
If someone has contracted COVID-19 and prior to that they were in the office, well, then you need to establish who they had contact with. So this comes back to the issue of trace. And in absence of any app that enables us to trace who we've been with and who has contracted the virus, then in my view, the employer should establish where that visitor went to within the office, who they had contact with, whether the people that they had contact with were masked or otherwise protected in a way, before leaping to the decision to close down operations. Even if they do close down operations for the purposes of a deep clean, then the question really is, of the people that individual was in contact with or close proximity to or closer proximity to, do they need to self-isolate? And I would verge on the side of caution and say yes, they probably should need to self-isolate.
Okay. Michelle, are you anticipating an upturn in cases relating to directors' duties in terms of cases against individual directors, or is that something that we need as business leaders to be aware of?
I don't think particularly. I think it's essentially if directors are not taking the financial health of their business seriously and are misleading suppliers, i.e. people that they are going to have to pay money to, about the financial state of their business. I think at this point, in this juncture, the best thing to do is to be as honest as possible with this, about your financial status with your suppliers. And if you are going to struggle to pay, to get a variation agreement in place, setting out a payment plan that you're confident you can stick to.
One of the questions I have is, and I think the answers are going to be a no, but I may be wrong. I have a good relationship with my suppliers and we have agreed to see how it goes. Is that enough?
Well, it depends on the status of your contractual relationship with that supplier. If you've only ever worked on a verbal basis, then it possibly is enough. But if you have a written contract that says how things have to be done between you, and if you want to change how things are done with you, that they have to be varied in writing and it has to be documented in a certain way and certain amounts of notice given, then no, then you have to follow what the contract says.
Okay. And I have a customer who is calling off stock ordered before the lockdown, but I am not sure they will be able to pay. Am I obliged to deliver?
Again, it depends on what your contract says. On a basic level, the answer is yes. If they've got a contract to acquire and you've got an obligation to deliver, then yes. However, as I mentioned before, you can look to see whether you have a termination for cause clause in your contract, which says essentially if you have a reasonable suspicions that your customer is not going to be able to pay you, that you may terminate the contract. If you haven't got one of those in place, but you might have a revision of title clause, it would be worth reiterating that with the customer and reminding them that whilst you're providing them with goods, they still belong to you until they've been paid for, and therefore have to be marked as belonging to you and kept separate from their other goods.
Okay, thank you. Question here, and this might be for both of you, can an employer tell employees that a fellow employee has COVID-19 and everyone else needs to be aware of the risk?
So I think that's a
yes.
You can go.
Yes, I would. I mean, apart from the obvious GDPR thing that Michelle will comment on, and I think even in those circumstances, this is all about keeping people safe. Frankly, if you don't say anything, the rumour mill is going to run rife.
Yeah, definitely.
Yeah, and under GDPR, as I said, even though this is special category data, because it is health data for which you need an additional legal reason to process it, the legal reason of public health and protection of employees both exist under Schedule 2 or 3, I can't remember which one it is. And so you are able to process that data as you need to, and if that involves sharing it with other people, then so be it.
Okay, so that's your get out of jail free card then, effectively. Yeah. Good, thank you.
I think one thing to say about health data is that you shouldn't keep it for any longer than it's necessary. So X years down the line, you shouldn't have on somebody's file that they had COVID-19 or they were living with somebody who had COVID-19. That data should be eradicated if it's no longer relevant.
I seem to have caused a bit of confusion at the start, or the first lot of questions. If people live with someone who is vulnerable, they are not their carers, but are risking bringing the virus home. The business cannot run without them doing this role. Do they need to find a new job? Seems a bit extreme, but I'm not sure what they'll do. So if people living with someone, but they're not their carer, but the person they're living with is vulnerable and they are risking bringing the virus home, but the business cannot run without them doing this role. Do they need to find a new job? What's their status for employment there?
The obvious question is, well, can't they work from home? Is it necessary for them to come into work to do their job? If they can't do it, can they not do it at home? If they really can't do it from home, then the question really is that, looking at the government's guidance on furlough under the coronavirus job retention scheme, you can furlough them and find someone else to take that role on.
Okay, so I've just had another message come through. The individual involved cannot work from home.
Yeah, well, that's the second part of my answer then.
So I suppose it's a furlough issue, or whatever. They may be on self-employed terms or whatever. So yeah. I suppose, as with all these things, trying to answer questions on individual cases can be quite challenging, but by all means, bring it up with us at the end of the event or email.
I would urge the listener or watcher to not leap to dismiss someone, because I think the problem there is that if you've got someone who's protecting a vulnerable member of their family, who is extremely vulnerable and probably therefore disabled under the Equality Act 2010, dismissing someone essentially will be challenged as dismissing someone who is associating with someone who is disabled, and that would be a disability discrimination claim.
Okay, and one very quick question before we wrap up and move on to a little bit of housekeeping. Very practical one. If they're working from home on a PC for many hours now, can they ask for a proper chair? I would hope so. Because my back's killing me on this kitchen chair, and it's not that wasn't a question raised by me either. It was raised by somebody else.
Yeah, well, look at your home working policy, because that will set out what conditions are needed to work for home effectively and successfully. And if you haven't reviewed your working from home policy lately since the 1st of March, well, now is the time to do so.
So now there'll be a massive rush to Amazon to click on for office chairs, I think, after that question. There you go. Brilliant, guys. Thank you very much for that.
Andrew, before you, can I just share one bit of the screen? I found that 5-point checklist. Can I share that?
Thank you, Nick. Yeah, share away.
There we are. Here it is. Right, so you will find this within each guidance, each of the 8 guidances. You will click on this. It's a PDF document, I think, within the guidance, and it sets out the 5 steps. 5 steps to safer working together. And the 5 steps that I read out, we've carried out the risk assessment, cleaning, etc. And there you are. That's the bit that you sign your life away and date. And your health and safety representative is Andrew Metcalf.
Not in my office, it's not. I'm not taking that responsibility. That's way above my pay grade.
But you need to include this bit, the HSE and their number, their free phone number. There we go, ladies and gentlemen. And
Nick, quick question. Should that be inside and outside your building to show for deliveries or not?
It should be inside. If it's outside, you need to waterproof it.
Yeah. Good. See, ladies and gentlemen, so many practical benefits of being a member of Kent Invicta Chamber of Commerce. You never even knew, did you? Fantastic. Superb. Thank you very much for that. Molly, could we possibly go to the share screen and I'll just talk through people through what's happening over the next sort of week or so.
Sorry, Andrew, can I interrupt again?
You certainly can, Nick. Get on money's worth.
We have produced 3 guides on construction, office, and also factories and warehouses. What
Brilliant.
we've done is that we've produced these 4 bits of guide to whittle down the 31-page guides on each sector down to a more manageable, easily digestible size. And I've tweeted and linked in 2 of those this morning, and I will be doing the construction one shortly.
Fantastic.
So link in with me or follow me on Twitter at Nick_Hobden.
Fantastic. Thank you very much, Nick. Superb. Okay, so webinar dates for your diary. Returning to work, we've got a guide for the construction industry. So if anyone's in the construction industry, on Wednesday the 20th of May, that should be another useful one, especially for those in that sector. And then there's going to be a future of the workplace, and I'm sure that's what's troubling lots of people and concerning people, not necessarily losing sleep, asking, you know, what is the future of the workplace as we go forward and come out of that. So that's on the 21st of May. In terms of are there any other ones there, Molly, or not? No. So all that leaves me now to do is just to say there is a poll that's on the event. So please give your details, give your feedback, let us know exactly how you're feeling. We're not shy, not embarrassed to, you know, just tell us the truth. We'd also like to hear from you as well, any thoughts that you might have on what business critical issues we should be having as webinar subject matter. Because at the end of the day, we're here to serve you as members. We need to make sure that you are best place to come out of this, and anything we can do to help, we will do as a chamber. Also, if you haven't already done so and you've got specific COVID issues and questions, there is the COVID helpline, which is run through the Kenton Medway Growth Hub. That is a free service. It runs, I think, I may be wrong, but I think it's 8:30 till 5, Monday to Friday. I should know the telephone number, but I don't, because I'm bad. But I'm sure Molly may quickly suddenly flash it up on screen, take it down. I have to say, it's had, I think in 7 weeks, over 6,000 businesses have logged on, called through, and received one-to-one advice over the phones. There's then been one-to-one meetings with people. She's fantastic, Molly. Right, the telephone number, if you're all sitting comfortably and your bums haven't gone numb, the number is 03333 60 2300. I'll say that again, it's 03333 60 2300. Anything you've got, any questions, that is a free support service. It's funded by KCC and district councils. So fill your boots, everybody. It's, you know, you don't hear that every day, but they have really stepped up and are working with Invicta Chamber and also with the Growth Hub to make sure that it's relevant and appropriate for you. So all that now leaves me to do is thank our two speakers, Nick and Michelle from Thomson Snell Passmore, and stay safe and stay alert, everybody. Whatever that might mean, I'm not sure. Anyway, stay alert, and if in doubt, read the guidance.